All right, good morning. It's January 9th. This is Senate Judiciary. We have Senator Hardy here with us to give us a introduction to S-195, and we'll just hand it over to Ruth, or Senator Hardy, and thank you for being here.
You're welcome. Thank you, Senator Hashim. Yes, so I'm here to tell you a little bit about S-195, which is a bill about criminal procedures and conditions of release, something you are all much more familiar with than I am. But this came about because, like a lot of communities, my community, and particularly in Middlebury, has been struggling with people who are repeatedly causing challenging situations, a lot of property crime, a lot of smashing windows, sort of harassing behavior in our downtown area, and a lot of them have repeat offenses where they're doing it multiple times, and then being released. I'm wearing the mask because I have a little cough, and of course, right as I start to speak, my cough comes.
Oh, no worries.
So excuse me. Sorry. So I was trying to figure out a way that we could address this situation where people are repeatedly doing the same behaviors. And it turns out the same thing is happening in Rutland, and a lot of the people who are doing it are actually apparently the same people who are going back and forth, or at least in a few occasions. That has been the case. So Senator Palmore and I were working together on it. So he's the other co-lead sponsor. And in our research with Ben Novogroski, who just walked in, we realized that addressing it through bail was challenging and maybe not appropriate, but that conditions of release may be a better way to go. So what this bill would do is require that judges take into consideration repeat offenses when they're setting conditions of release for individuals. Apparently that is the practice that a lot of judges already do engage in, whatever. But this would require it. So it would basically codify some of the current practices of some judges, but not all judges, and require that they take into consideration how many times somebody has had a similar offense or has repeated the same behavior, and make sure that they're taking into consideration for the protection of public safety. So that's all it does, and Ben can walk you through the more details of how it does that. But that's really how it came about, is to try to address repeat offenders who are doing the same kind of, creating the same kind of behavior in our communities. So,
thank you.
Conditions of release.
Great, thank you.
Welcome. I'm happy to answer questions if you want. And I know that Senator Collmore wanted to be here, but he had to be gone for an appointment today.
Well, thank you for stepping in for Senator Collmore. I think I'll have some questions that might end up being for Judge Zone or maybe Ben, but no, I appreciate the general overview of the bill. And yeah, do you folks have any questions?
No, I think the questions that I want to have, I'm going to more or less refer to Ben.
For Ben.
When it comes time to.
And I did touch base with Judge Zone while we were working on the bill, and he confirmed that he's the one who's doing it. A lot of judges do this already, but this would require them to do it, so that, you know, that could be part of their condition of release. We had a couple businesses who were repeatedly targeted, and so, you know, they could set conditions of release that are specific to staying away from certain places, but they had to take into consideration this repeat behavior.
I think actually just generally, I mean, do you or, you know, the other sponsors on this have thoughts as to, you know, the enforcement mechanism for these conditions of release? Because, you know, while I think that, you know, while some judges may do this and others may not, you know, what I'm also hearing is that, you know, regardless of what gets assigned as a condition of release, there's just a lack of enforcement for it or any form of supervision. And is there any, so that, that's kind of like the second half of this. So did you have any thoughts on that, or is that?
Yeah, so I didn't go down the enforcement route, mostly because this is an area of law that I'm not as familiar with. So I figured this would get the conversation going and that you all would take it from here and really try to figure out what would be an appropriate enforcement mechanism, or if this is the right angle. I know you have multiple bills and ideas about how to deal with, and I also, want to say that there's a perception of increased crime, but I think compared to a decade ago, our crime rates are still quite low in Vermont and are lower than they were. So I want to make sure that we're really looking at what is the data, and I'm assuming that you're all going to do that and look at the data and really create an appropriate response to the data that's statewide. So this was a bill to try to start the conversation on, it's hard for communities when the same people are doing the same behavior and people are feeling unsafe and people are feeling like this isn't fair that this person continues to do this. And there are a lot of mitigating factors, substance use and mental health and poverty and all those mitigating factors that we see all the time. And I know that you all talk about in here a lot. So I don't think this is the be all end all solution. What I was thinking, and I think Senator Collmore was thinking, although I don't want to speak for him, but I think we were thinking it was a starting point for the conversation, and that, I talked a lot with Ben about options, and this felt like the most comfortable place for me to start, given that I don't work in this area as much, and that you all would dig into it a little bit more. And you'll note that Senator Sears is one of the co-sponsors, and that was really he and I again don't want to speak for him, but he and I talked about it and saying, that this is a good place to have it on the table.
Yeah.
So
sounds good. Thank you.
Yeah.
Great.
Yeah. Well, thank you very much for having me and for taking this up. There's a lot more people who know more than me, especially Ben, who's sitting down at the other end of the table, and he can talk about this, but hopefully it will get the conversation going.
Absolutely. And Ben's up next. So yeah, thank you.
Nice to be here. See you both later.
Yeah, take care.
Yeah. Oh, hi.
All right. Good.
To get set up. Morning, everybody. For the record, my name is Ben Novogrodski from the Office of Legislative Counsel. I'm here to walk through S-195, which is an act relating to how a defendant's criminal record is considered in imposing conditions of release. Senator Hardy, I think, kind of captured the spirit of the bill well, and it was definitely my understanding as well that this would most likely be a starting point to a deeper discussion. As far as the bill itself, as you see, I also passed out 13 VSA 7554, which is the full clean version of the statute that this bill proposes to amend. Outside of just some sort of gender neutral language updates and consistency with definitions, the substance of the bill you'll see is on page 2 in subsection A, subdivision 2, which adds, it reads, if the judicial officer determines that conditions of release imposed to mitigate the risk of flight will not reasonably protect the public, the judicial officer may impose in addition the least restrictive conditions or the least restrictive combination of the conditions listed in the subdivision that will reasonably ensure protection of the public. The number of offenses with which the accused is charged or the recent history of pending charges against the accused or both shall be considered by the judicial officer as bearing on the determination of any conditions or combination of conditions that will reasonably ensure protection of the public. Now, when I drafted this bill, It was earlier in the summer as I was really just delving into bail. So I would make a humble suggestion as far as the location of this language should change slightly. After my discussions with Judge Zone and various prosecutors, I think that this should be moved from A2 to B2, which is the list of factors that are considered in the conditions of release, public protection factors. So just a small sort of, I guess, format change. The substance would remain the same. But what this does is provide that consistency that Senator Hardy was alluding to, is that while a lot of these factors may be considered by judges throughout the state in issuing or imposing conditions of release, this would ensure that it's consistent throughout the state and it doesn't vary by judge to judge. So how much weight that they put or whether or not these are even considered. Because if you look in subdivision B2, which is on page 4 of this bill, it says that the judicial officer shall take into account the nature and the circumstances of the offense charged, the weight of the evidence against the accused, and the accused family ties, employment, character, and mental condition, length of residence in the community, record of convictions, and record of appearance at court proceedings or of flight to avoid prosecution or failure to appear at court proceedings. So those are the factors that are considered in issuing conditions of release that are tied to public protection. Because if you'll remember from the presentation last week, there's bail, which has to do with risk of flight, but then there's the public protection factor, which is separate and a part of bail. They can be connected in some way, but again, the primary purpose of bail is not public protection. That's why these are tied to that public protection language rather than the bail language. And that really is to keep that kind of constitutional divide that's necessary between the two. So I guess in summation, it would be the number of offenses and the recent history of pending charges. So those would be things that if someone comes to court would be considered. So if they have a litany of charges currently pending against them, that's something that can be considered in a public protection analysis. It can also be how many are already considered, that would be considered. So again, providing that consistent language from judge to judge throughout the state so that that would be considered in those, and imposing any conditions related to public protection.
And just to confirm, your suggestion was to change it was to relocate the language from section A2 to section B2?
Correct. So it would just join that list of other factors that are already considered.
Yeah. Yeah. I think at first glance that makes sense. I do think that since Senator Sears is one of the sponsors of this, just want to run that by him first. But yeah, so,
of course, I just wanted to get it on the record for your consideration.
Thank you.
I got one question. It's been a while. Obviously, you may have to refresh my memory from the testimony that Senator Hardy, the sponsor of the bill, co-sponsor of the bill, whatever, gave was that simply we have an individual going back out and reoccurring offenses happened. So, and it still refers to, we're looking at still setting conditions of relief or more stringent conditions of relief.
Right.
So under Rule 3, continuance of the offense, why won't law enforcement simply look at dislodging this individual, never mind the conditions of release because it's continuous of the offense, or would that individual have to go back to the same store, same window, break it again, or doesn't apply with other stores or any other damage that's being done throughout the county or the state? I'm trying to get, what are we trying to accomplish here?
Is that these would be considered in the public protection analysis. So if, again, the conditions that are tied to keeping someone so that they can return to court, if those are insufficient to achieve public protection, these additional things, the number of offenses and the recency of charges pending against them would be considered in public protection. So you could kind of, just to extrapolate, you could say if this person comes before a judge and they have 5 retail theft charges currently pending against them in a separate case, that could be tied to, okay, well, that person might present more of a risk to the public because they have all these charges currently pending. And that's something that could be considered in the analysis of imposing further restrictions on the release.
So that still would preclude law enforcement from taking the necessary action under Rule 3 and doing what they want. This is what we're talking about, the appearance before a judge.
Right, when you say Rule 3, what are you?
Continuance of the offense, the logical.
Of the rules of criminal procedure? I guess I'm not as, I would need to refresh my memory on that.
Oh, you made it refresh mine too, it's been a while. Maybe one of the other attorneys or the judge can enlighten me or us
Sure.
on that particular. So this is when the individuals appear before the judge and he or she decides to set conditions of release or more stringent conditions of release. Is what we're referring to?
Yes.
Okay.
And again, all of this, and without refreshing myself on Rule 3, but you know, this is all tied against the backdrop of, you know, people are innocent until they're proven guilty. You know, you're balancing their liberty interests because they haven't been adjudicated of an offense yet. So that's paramount in due process in our constitutional system, but how it's balanced out is that public protection factor and all that. So that's why, and we'll get into on Senator Sheen's bill next, why you need to kind of have that balancing already in mind. You can't necessarily detain them, or you can't impose restrictions that are essentially banishing them to some sort of confinement before they've been adjudicated guilty. So that's just an overarching concern that is present in all of this.
Thank you.
Thank you.
All right. Thank you, Ben. All right, so next up we have Tim Luters Dumont from the State's Attorney's Office.
Tim Luters Dumont, Department of State's Attorneys and Sheriffs, and it struck my memory last year, you guys were talking about Rule 3, just before we go to the bill, concerning S36, the hospital bill. And the one that you're talking about is Rule 3C, and the continuation is 3C3. So the arrest is necessary when there's probable cause for an unwitnessed misdemeanor to prevent the continuation. So the way I think about Rule 3 in that context, when I've talked with folks like yourself, when there's something happening, is it's a kind of immediate transaction. I think the context with respect to the bill that you're talking about today is more when the person commits a series of alleged criminal conduct and then they come before a judge, they go back out. It's sort of a little bit more of an extended time period, but Rule 3 to me is that more immediate. You know, the person is actively engaged in it, or you've been told by, for example, a hospital worker, the person has now come in here 7 times today. We have a no trespass order. Their detention is necessary in that immediate context to prevent the continuation of ongoing criminal activity that's been alleged. So that's the way I always think about Rule 3. It's much more immediate, and that's in the non-witness misdemeanor context for what it's worth. I sent that link over to you and Ledge Council just for you to have it helpful. So getting to the bill, I did speak with a number of our state's attorneys about this, and I think Legislative Council's comment about locating it in that other section is something we would agree with. We do think that many judges do absolutely consider this. We haven't had a real issue with judges not considering things like this in the conditions of release analysis that often happens at arraignment or after someone's charged, when you're saying, you know, oh, it looks like there's some conditions that could be put in place here to protect the public. I do think it's helpful to put it in that list of other things as Legislative Council recommended. You'll note in my testimony from last week, which seems like a couple weeks ago at this point, but I did recommend on behalf of the Executive Director's Office and the Executive Committee of State's Attorneys other bail-related amendments. So those are on your committee web page. I didn't want to dwell on them too much today because that's another section in the bail statute, but that would be in the analysis. It's related in that it's in the analysis as to whether imposition of bail or conditions should be put in place to mitigate the risk of flight for someone that has alleged non-compliance with court orders. So that you have that on your committee page. I would recommend you consider that as a part of when you're looking at the bail statute. And if you guys have any questions, I'm happy to answer them about our, the perspective or practice questions. But other than that, I really didn't have much more on this bill. We don't have a kind of a in favor or not in favor position on this. We think it could be helpful, but we haven't had many issues with judges in terms of conditions of release and the imposition of those conditions. We argue those at arraignment. Sometimes it, quote, goes one way or another, but we haven't had many issues with judges not considering things in the conditions analysis. We have had some issues from our perspective in terms of the imposition of cash bail to mitigate risk of flight analysis when we've seen non-compliance with court orders and failures to appear stack up for an individual. At times, I've heard from the field that some prosecutors have been frustrated that non-compliance with court orders and failures to appear are not considered in the bail analysis, and they could, right? They're not, that they couldn't, but that's why we've made those recommended amendments, which are on your committee page.
So, my question for you is similar to what I posed to Senator Hardy earlier, regarding the second part of conditions of release. What I'm kind of concerned about is, creating this change, but not changing anything in the second part, which is enforcement or supervision, and what comes next, if these multiple offenses are taken into consideration. So I know it's a big question, but do you have any initial thoughts on that?
Well, this is something we talked about with both of these gentlemen behind me in the fall and the summer about what, Vermont doesn't have a pre-trial supervision system. Law enforcement is understaffed, and so law enforcement, if they run across someone or they're investigating something and run across someone and they see, oh, that person, they call, a prosecutor and they have the condition not to have contact with the victim, and where are they? They're at the victim's house. That's how violations of conditions of release are often filed. And that's the state of pretrial lack of supervision. So one Supreme Court justice did refer to them as the paper tiger in terms of conditions of release. I think that most of our prosecutors would probably agree with that.
Gotcha. And if you don't have an opinion right now, no problem, but do you have any thoughts on GPS monitoring as it relates to things like curfew or as it relates to curfew?
I think that anything we can do, whether it's, and I know there's some restrictions, there has to be that other analysis in the conditions of release part of the bail statute, and one can have those more elevated, more aggressive conditions of release imposed on a person, like a responsible adult. There's supposed to kind of be extraordinary type of circumstances at play to have someone attached to someone's supervision, essentially, in the community. But again, we did talk about it at Joint Justice a little bit. Home detention right now is basically reserved in terms of the population for very, very, very serious alleged crimes. That's why it's been a small population, because they all have to be subject to bail first. And then that initial net, you go forward, and then home detention analysis occurs. So that's why it's a small population. Certainly, Vermont has some issues with passive monitoring because of lack of connectivity. So someone in an area where you would receive cell phone service might say, okay, this person's a good candidate for passive monitoring, but for someone that doesn't have service in an area, it'd be less likely. But I know, and I'm not sure if the Deputy Defender General can speak to it, but there's some work that's happening to better communicate with clients via text or other electronic means. Exhausting all of that would be a good thing to look at, for sure, whatever that is. GPS monitoring, more automatic texting, automated phone calls, etc., to any and all means to get people to engage in their own prosecution is helpful from our perspective.
Thank you. Anything from you guys? Good. Great. Thank you, Tim.
Good to see you all.
You too.
Yes.
All right. Doing good on time. And next up we have Marshall, the Defender General.
Good morning. Thank you, Senators. So I'm actually surprised at this. I came into this hearing expecting that what we would be testifying to was to say that what I expected to hear is that there was a bunch of cases where judges were, in my opinion, misreading the law and determining that they could not consider the number of offenses that someone had committed in setting conditions of release around public safety. And if that was the case, we were prepared to come in here and say, we don't oppose this bill because, frankly, from our reading of the law, it's already the law. If you look at section 1 of 13 BSA 7554, in fact, the only consideration that judges are, the only piece of evidence judges are actually required to consider, they may consider any piece of evidence, but the only one they're required to consider is the number of offenses that someone has committed. And then subsection 2 essentially refers back to subsection 1. Subsection 2 says, taking all of the evidence that you've considered in subsection 1 about risk of flight, now use that evidence to set conditions related to public safety. So from our perspective, this was already the law. Judges could not set conditions of release around public safety without considering all of the things in subsection 1. The one that's named explicitly is the number of pending charges that the person has. So from our perspective, we came in here expecting that there was some problem going on where judges were not following that. And what we're hearing instead, in fact, is the state's attorney's office saying, we don't actually see a problem with this. We don't see this. We don't think that there are judges who aren't considering this. And on that basis, I think I would sort of change our position from being one of kind of ambivalence where we're saying, we don't see this as a problem, but if this needs to be corrected in order to clarify it for some judges who aren't seeing the picture, if this is actually, if judges are already doing this, and if there's no dispute that this is something that judges are looking at, then we don't see the need for there to be an additional law. The part of the reason why we feel resistant to that is there is a sort of a rule of statutory construction that's applied sometimes and not other times, that essentially when the legislature changes a law, they mean to change the meaning of the law. So if a judge looks at this and says, the legislature added this in, even though it was already part of the law, they're sitting there going, well, what does that mean? What meaning can we attribute to that change? And we don't see a need for there to be any change in the meaning of the statute. The statute already spells out that judges should be looking at the number of offenses that people commit. And frankly, having done, quite a number of arraignments and quite a number of motions to modify conditions of release, I've never had a judge not consider, when I've had a client who's had multiple charges, I've never ever had a judge not consider that. In fact, a lot of the times it seems like it's almost the only thing that gets considered. So we don't support this, not because we think that it is bad policy or because we think it is bad practice, but because we think that it is already policy and already practice, and are worried about what the consequences are of making changes to a section without really having a purpose for doing that besides restating what the law already is, that'll lead people to believe that those changes were there to change the law, not to sort of restate the law.
I take the point, Marshall. I'm just wondering if we're restating it, and as you say, the assumption is that there must have been an intention behind restating it. Is it reasonable to assume that the judges would say, this is just bumping this up in my awareness and making sure that I'm thinking clearly and thoroughly about the conditions that I'm imposing?
If you're asking me to tell you what judges would think,
I'm listening.
I struggle with that.
In other words, would it? I see what you're saying, but if you're moving from neutral to opposing the bill because it restates existing law or emphasizes existing law, I'm not sure I understand that changing.
I think we would, we would be, we wouldn't have as much of a problem with it if there was, for example, a statement of legislative intent that said the purpose of, including this in, I think the new proposal was to move it to section, B2 instead of A2. That the purpose of including this in section B2 is simply to clarify that this is already a consideration that judges should be making. That would ease our concerns.
Thank you.
So I also want to ask the same question that I've asked everybody so far. It does seem like this bill is more of a starting point regarding conditions of release in the conversation. And, the challenge, well, I'm not going to repeat the whole spiel, but any thoughts on enforcement and supervision?
Yeah, I actually, from my perspective, this idea that there's no mechanism for enforcing conditions of release where the conditions of release are not enforced just doesn't make sense when you look at it from a boots on the ground perspective. I mean, it's been a while since I've looked at the statistics, but at least fairly recently when the legislature last looked at VCRs were either the third or fourth most charged crime in Vermont. In some counties, they were taking up close to 30% of the docket was nothing but violations of conditions of release. And in every county, it was at least 10% of the docket was violations of conditions of release. The idea that they're not being enforced just doesn't make any sense at all. In fact, a lot of times we look at it and wonder, it looks like that's all that's being enforced is VCRs. We have clients who get charged with many, many counts of violations of conditions of release. So from our perspective, it's very much being enforced. It's one of the most enforced laws in the state of Vermont. I think misdemeanor domestics and DUI ones were the other, I forget which order they fell, but those were far and away the three most charged crimes in Vermont. So we would just simply disagree with the premise that there's no enforcement or that there's enforcement problems.
So I think maybe enforcement wasn't quite the right word, rather, how do we address supervision? Because at least from what I hear from the public a lot is, people feel that, individuals will rack up these conditions of release, they'll be given either curfew or assigned to a responsible adult and the curfew is violated very promptly. And again, these are anecdotes that I'm sharing just to be candid, but I think the issue, rather than enforcement, is more so related to supervision and how some of these conditions are managed for the people who they're imposed on.
I think it's helpful to look at what we offer in terms of supports for people who are released. So if you take a look, for example, there's two kinds of conditions of release. There's conditions of release that are set upon arrest prior to appearance. And in the past, those conditions of release were addressed very quickly by the court. Those people would have a prompt appearance in court and they would be out on conditions of release pre-charge for a very short period of time. And then a court would have a chance to review those conditions of release. A lawyer would be there assigned with the person to sort of identify if there was problems with those conditions of release, if there was problems with those people being able to comply with conditions of release, and to try to either modify the conditions of release to make them something someone can succeed at, or get services in place to help them succeed at those conditions of release. What we see because of the court backlog is longer and longer stretches where people are, cited out for much greater lengths of time, meaning that they are on conditions of release, but have had no court appearance, have had no lawyer, have had no access to services. Their lives nothing has happened to change their lives. All that's happened is they've been given a slip of paper that says you must follow these conditions. And frankly, that can be really difficult for some people depending on what conditions are imposed and what the circumstances of their lives are. So I would say that the backlog factors into this in a pretty significant way. And I would add to that I think that when you look at jurisdictions that have been more successful with getting compliance around conditions of release, they've done so by providing services. They've, the federal government's pretrial services program does a really excellent job of introducing services early, at the very earliest stages, voluntary services, but services where you get a sentencing benefit if you comply with them. And those services are all designed around helping people to comply with their conditions of release. In Vermont, we don't do much like that. We sort of turn people loose. We say, okay, your conditions of release, and these conditions of release can be really difficult. They may be, don't drive, don't, stay away from, many members of your family, many friends, many people that you are attached to, things that are very disruptive to people's lives. And we don't give them anything to support them in complying with those conditions. That all sort of comes later, that, services usually start to show up post-sentencing, or at least, and so I would say that's, if we're looking for more compliance, what we need is more services available immediately. The immediacy of services is key to sort of pro-social compliance.
Thank you. And so any opinions on GPS monitoring as a sort of pretrial service to support compliance?
Again, it's proven very difficult in Vermont. I think ever since I've been coming to the legislature, starting in 2015, we've been talking about GPS monitoring and pretrial monitoring, and every sort of iteration of that discussion has been unsuccessful. I don't know whether technology has changed or resources have changed enough to make it successful now. But just based on our historical experience with the program, I wouldn't see it as a promising.
Oh, thank you. Any other questions?
I was just gonna say, I agree, every discussion we've ever had about GPS has terminated in bad internet connectivity. And, then you're unsure if it's the person wearing the bracelet or if it's,
Right.
a genuine outage.
Yeah, that's good to have that background on. So, yeah, thank you. All right, thank you, Mark.
Thank you.
Judge Zellner?
Morning.
Morning.
Tom Sonnet, Chief Superior Judge. I was waiting to hear what the judges thought.
I don't think it would be wise for Marshall to speak for the judges.
So, I've listened to the discussion so far. I'm not giving a legal opinion, but I will tell you that if I'm many times on the bench when I am issuing conditions of release, I had kind of a format I would use, and I would go down the nature and circumstances of the offense, and I would just kind of start hitting all of them. The number of offenses, history of, so I would have a number of things I identified. And I always talked about the number of offenses, their violations, what's pending, things like that. And so this bill would not change how I have historically ruled. And hearing from Mr. Leaders-Dumont, it wouldn't apparently change how most judges are ruling. What it would do is make it very clear to everyone that these are the factors. And so I differ from Marshall a bit in that I don't agree that just because something might not be absolutely necessary, because it might be the way most judges, if not all judges, see the law, there might not be a benefit to it, because I think the benefit is for everyone to know these are the statutory criteria that a judge is going to consider. And so we don't leave it to the nuances of, is a judge going to take it from B1 and then consider it because he has to consider it under B2? And are we taking it from conditions relating to appearance and putting him in safety? Make it clear, and everyone's on the same page. And so I do not oppose making such a change. There is one thing I will say, and I apologize, I'm not trying to go sideways on things here, but it just seems to me that why do we have two different sections for factors? Why is the bill, why are we having these discussions about you have to go from here and then you go down to here? So I suggest that this might be a wonderful opportunity, as I said at Joint Justice Oversight, to look at to look at 7554 and maybe just at a minimum restyle it and then add what you want where you want. Have one set of factors that the judges have to consider. It simplifies things.
Mm-hmm.
And I just think that would be a step in the right direction. Again, substantively, I'm not saying you make changes X, Y, or Z. I'm saying that let's put it all in one place so that we don't have to have these discussions about do judges actually consider it? Should it be considered for this aspect? Mm-hmm. And I think that might be a step in the right direction.
Senator Rhodes.
So I have a question for you, but it's not related to what you just said. I have a question for Senator Hashim, or maybe someone who, I'm wondering if rather than passing a new bill that establishes a law that is already a law, if it makes sense to do the restructuring Judge Zoney is talking about in the miscellaneous judiciary bill.
If I could add a question on to Senator Kowalski's, I was thinking along the same lines. I'm wondering if you would be willing to supply us with draft language.
How did I know that might be something? My thought was that would be something, I actually thought ahead on this. I thought that would be something that some of the stakeholders could visit together on and see about if we could come up with something that would look. And I haven't talked about this much since the meeting with the Joint Oversight, but again, it was just something I thought of. I'm looking at Tim thinking, does it make sense? And Marshall, let's get it all in one place.
Yeah, I think
need to confer with the 14 separately elected persons.
Yeah, I mean, I don't have an initial opinion on whether that happens in the miscellaneous bill or this bill. I don't know how long or challenging the conversation might be regarding what the restyling would look like or if it would turn substantive. Ben?
Yeah, my suggestion would just be to use this bill as a vehicle for it because the miscellaneous bill has a lot of other things contained in it, and this may end up dominating the discussion about that bill at the expense of other provisions.
And I suppose that's the chair's decision to make overall, but I think the idea is a wonderful one, that if the stakeholders could be working together with the idea that we would find one vehicle or another. Because I take the point, and I'm always on the lookout for opportunities to simplify, especially for lay people who go to the statutes and aren't aware of how one thing might interact with the other. If we had one section that had the conditions and it was clear and black and white, I think that's a separate good from what we're trying to do with, the lack of, the perceived lack of enforcement.
And I know that in the past, there's been times that Ledge Council has put together a draft and then sent it on to those stakeholders and we've reviewed it. So whatever works best, I'd certainly be willing to assist you.
Go ahead.
So my other question for you, Judge Zoney, is less about this bill and more about the problem it's trying to solve. And so I'm wondering if you have available or could get us sort of the percentage of people that are out on pretrial release that have been there for more than a year, more than 2 years, more than 3 years, to just try and get a sense of like how much the backlogs and how long people are sitting on pretrial release is impacting this issue.
I can get you that information. Let me just do. This is not as of today.
Okay.
This is as of, I believe it was December 18th. There were, at that time, this does not include violations, probations, and those types of matters. This is just felonies and misdemeanors pretrial.
Mm-hmm.
There was, looks like 11,571 Of those, I can't tell from the chart I'm looking at how many have conditions of release.
And those are people or charges?
These are charges.
Okay.
These are charges. These are open cases. And out of that, there was 1,846 that were more than 2 years old. And then it's broken down every 30 days.
Mhm.
But 109 more than 720 days old, 115 more than 690. And I can do the math, but there are quite a few people out there for extended beyond a year who have been on
Okay.
conditions of release. And I know that right now, there are, as of today, I believe, 1,146 cases. I'm sorry, 1,416 cases where the violation of conditions is the most serious charge. In other words, that means there are 1,416 individual cases that someone has been charged with violations of conditions and not something else. And when I say something else, there could be a case where someone is released on conditions to not go to a certain store. And when they come back in, if they violate that, they could have a charge for unlawful trespass, count 1, and then violation of conditions, count 2. This number of 1,416 would not capture that. That's only the cases where you're charged solely basically with VCRs.
Mhm. And would that represent people for whom the behavior would not be a crime if they were not on conditions?
I can't tell from the data.
Okay.
So if I could briefly address that, if that's okay with you, Mr. Vice Chair.
Yeah.
So prosecutors exercise discretion when they're making that call. So sometimes they might say, the person has these pending cases, and we're gonna charge a VCR because they violated one of the conditions. They're making that call, and it would depend, you have to actually dig into each one of those dockets. You'd have to look at each one of those to see what the landscape of that person in that situation is. So I do think it's very difficult to make generalizations. I was talking with State's Attorney Goodenough this morning about this very question. And, you know, there also is circumstances where someone could charge 50 VCRs, but they're charging 1 or 2, or they're charging none. It sort of just depends. And the data on that is hard because we aren't demanded or commanded because of our discretion to charge VCRs. We choose to in certain circumstances, but we don't charge all the VCRs that come in. Sometimes we charge 3 when there was probable cause for many more, or sometimes we charge 1. So it's sort of very case specific as to those VCRs. And I just wanted to say, because I was on the phone with State's Attorney Goodenough on the way in this morning.
Anything further? Anything further from you, Judge? Okay, great. I do have one question. I'm curious about judicial discretion for conditions of release. You know, if the judge or the parties are aware that, you know, for example, for condition 4, somebody is being released into the custody of somebody else, if the court is aware that the other person is not able to actually, you know, help with the supervision of this defendant, does the court have any discretion in who the defendant is released to?
Yes, the determination of the condition for a person is one that's up to the judge. If a judge determines that there's not an appropriate condition for a person, a judge would not order that individual to be the condition for a person. I'm aware of, I believe it was a case out of Rutland within the past 6 months or so. I think it was Judge Corsone's addressed this issue. In fact, someone was there was a debate that went to the Supreme Court between the parties about should the judge have approved the person, shouldn't the judge? And so my understanding is the judges will exercise that discretion to determine whether someone is appropriate.
And do you have any thoughts on compliance in general and how we improve compliance? I mean, we heard about the court backlog and pretrial services, and I just wanted to pose the same question to you as well.
I think the longer someone's out on conditions of release, not seeing the end of the line, there is a greater likelihood that they may engage in behaviors that might cross the conditions of release. We have to take steps to make sure that we're resolving the cases from the time they come in to disposition sooner. Someone should not be on conditions of release for 1 or 2 years. They should have the case resolved. That's not fair to the victims. That's not fair to the defendants. That's not fair to the public, that things drag on. And so we need to take steps to address that. Compliance is always going to be a situation where the legislature enacts laws that say you can't do something, and someone does it. And then they come to court. So the first question is, well, why did they violate that law? How do we get compliance with the law? So we're wrestling with that. And then as a subset of that, we impose conditions. And some people will follow those conditions and it alters their life, and some won't. And so the next question, as you point out, is, well, how do we get those people to comply? Because again, some people are going to comply. And the conditions should ideally be structured in a way that encourages compliance and provides a mechanism for the individual to be successful. Because that success for that defendant leads to success in the public and for the victims. If someone is going to follow the conditions for no contact, if someone has conditions for substance abuse treatment or mental health treatment that they're going to go forward on, and those conditions are followed, that enhances compliance. If we have individuals who are identified to be a condition for a person, and information is brought to the court that they would be someone who could properly supervise someone, that ensures compliance. And so the idea that there's non-compliance as a function of anything, in some cases, other than the fact that some people just don't have the tools, we have to recognize that's the way it is. If someone comes in and they're a raging substance abuse issue, and we tell them, don't go use heroin tomorrow. Well, my question is, if I came in and told people we drink coffee every morning, by the way, tomorrow morning you can't have coffee.
And for 2 years from now.
For 2 years, because you have had a coffee problem. And I don't mean that lightly. I think that's something we can all appreciate. Like, wait a minute, I do this. And so, well, what tools can we help people with? And that's why last week there was talk in this committee about, well, what do they do in Illinois? Well, they have pretrial services. And so we hear about that. And so I guess one of the things that I always look at is, are we giving the individuals the tools to comply and to aid them in their compliance? And so I think that's important.
Thank you. And I also imagine we'll be talking a bit more about the backlog and pretrial services, hopefully tomorrow in our joint hearing, so we can take a deeper dive there.
We're on for the backlog. We have you there, and we'll answer any other questions.
Thank you. Anything else? Great, thank you.
Thank you.
You have something?
Thank you.
Okay. Thank you, Judge. So we're doing good on time, so let's take a break.